So, as before, you interrupt when you don't understand. So, mens rea, c'est l'élément moral, ou l'élément psychologique, whichever way you want to call it. There is absolutely no statutory definition of it. So it's purely common law, and nowadays you had a bit of doctrines on scholarship writing about mens rea and trying to define it. The cases are mainly on the most serious offences, so murder and manslaughter, l'homicide intentionnel ou l'homicide non intentionnel. So it's not always clear, to be honest. I think even if you take the French code and you take 1213 of the criminal code in France, it's a long article, 4 alinéas. It's not clear in itself. It's not that easy to implement. And you have plenty of PhDs on this. PhDs are les thèses. So it's just an outline here of the possibilities and trying to show you how it works in relation to the French law. The presumption is always the same. If Parliament hasn't said and hasn't used the word intention, unless it says differently, it will be presumed to have intention as mens rea. So that's really, really, really clear. By the way, can you hear me, or do you want me to use the mic? Mic? Is that better? Yeah, that's better. I can hear myself. Do you want me to repeat then the last few seconds? Yeah. So mens rea has no statutory definition, so no legislation on it. Mainly the cases. It will be mainly cases on the most serious offences. So the homicides. Homicides is either murder, l'homicide intentionnel, or manslaughter, l'homicide non intentionnel. You have a bit now of scholarship on intention and mens rea, but scholarship in criminal law has never been really developed. It's completely different from French law, where you have a lot of PhDs, les thèses, on the intention and negligence and all this. I think English law is much more pragmatic. So you need to look at cases, but the one rule to remember is if Parliament doesn't say anything, Parliament is supposed to have required intention as mens rea. So if you don't have any words that ever indicate intention or indicate something that is not intention, so negligence, recklessness, or something else, it will be intention. Now there's three possibilities. The key one is intention, like si vous prenez l'article 121, 3 alinéa 1er, les crimes et délits sont intentionnels. So intention. Below that, you have recklessness, and recklessness is la mise en danger délibérée. Negligence, and donc, sorry, recklessness is not just la mise en danger, c'est la mise en danger délibérée. Negligence, and we'll come back on it, it is actually gross negligence. It's not just negligence. So it's much narrower scope than French law. The other aspect of defining mens rea, whichever it is actually, intention, recklessness, or negligence, is that a lot of those cases are going to go to the jury, because the competence of the jury, the jurisdiction of the Crown Court is much wider. More or less, you've got a jury for any type of what France will say as délit, whereas remember in France, la cour d'assises with a jury, it's only for les crimes. Okay, so it's much broader. So if we have a case up to the Supreme Court, it tends to be a case with the jury, and therefore it creates difficulties to understand sometimes the case because the jury decides on the facts and what the argument will be on the direction by the judge to the jury. So it's always a bit difficult. But intention is defined in two ways. The first one, which sounds completely obvious, is direct intention or direct intent. And it's the will, or we say the willingness or the will to reach the result punished. So it's the aim and purpose is to achieve the result in the offense. Okay. And that obviously is completely independent of the motive. It's like French law. Intention is not about motives. So whether it's for revenge, for personal reasons, for altruistic purposes, it doesn't matter, as long as the person has the willingness of the conduct and of the result. So acting with the aim and purpose to achieve the result. Now there's another definition of intent. It's called oblique intent. It's a bit of a strange expression, oblique intent or indirect intention, because it seems to imply that the person did not aim to achieve the result. It's a bit more subtle than that. What it means is that the person has the foresight of a virtual certainty. So it's the last word on the slide, virtually certain. The person has the foresight that it is virtually certain. So the person engages in the conduct, may not actively research the result, but knows that the result is virtually certain to happen. Okay. And virtually certain is a very high threshold test. Literally, it's only if a miracle happens that the result will not be there. So it's very close to direct intention in that sense. It's just that prosecution cannot necessarily prove that the defendant said that he wanted to achieve the result, but the prosecution can prove that the defendant has the foresight, the ability to see that the result was virtually certain and only miracle will stop the result to happen. So it's a very high threshold. I didn't give you the case because I thought it was it's the Woolling case, W-O-O-L-L-I-N. I don't think it is that important. I know it's supposed to be a common law and system and they're supposed to give you all the cases, but I think it's more the concept of virtually certain that for me is important. Now there are specificities for murder in terms of what is intention, and I think this is really, really important to remember. If you take murder, so l'homicide intentionnel, normally the definition with direct intention, as much as oblique intention, should be that the person wishes to kill somebody. Murder is, at the end of the day, the result is death. Okay. The difference with l'homicide non intentionnel is the intention, so the mens rea, so that willingness to achieve death. The problem is that English law has widened that scope and that understanding to include intention to cause serious bodily harm. So you don't need intention to kill. You can have murder, that is, in terms of actus reus, you have the conduct and the death as a result, but the mens rea will not match the actus reus. Mens rea can just be the willingness or intention to commit the conduct and to cause serious bodily harm. We also call it GBH, grievous bodily harm. Okay? So it's much wider. It's a choice that the UK has done, and it's not the choice that France has done. France, when we can't prove intention of death, but we can prove intention that the person wanted to seriously injure the victim, then we say c'est les coups et blessures intentionnelles sans intention de la donner. On a l'infraction spécifique. England brings it under the murder scope. Okay, so that's really important because we give you this definition of intention. Intention matches the conduct and the result. Well, it's true except for murder, which is quite striking because it's the most serious offense, and you'll think that at least they would require intention to kill and to cause death, but it's not the case. So it's a lower threshold, and English lawyers, as much as judges, are fully aware of it. The case that I quoted last Monday for legal certainty and understanding the role of precedent and overruling, that same case, I am quoting here paragraph 83, murder already has a relatively low mens rea threshold because it includes an intention to cause serious injury without intent to kill or to cause risk to life. Okay, so it's something that they are fully aware, and the doctrine, the scholars have given a name to that. It's called a constructive crime. So that's what I put in red at the end of the quote. Professor Smith is an author. He died now. He wrote his first book in the 50s. His book now is taken over by Professor Omrod. You remember for the Law Commission I talked about Professor Omrod last week. He is the one who wrote and said it's constructive crime. What does it mean? It means we are constructing an offense and a crime, therefore, on the basis of the facts. So the facts are a conduct and a result which is death, and we are constructing intention in relation to death. Okay, so it is controversial, to be honest. The Law Commission with Professor Omrod is trying to have this changed. They would have, in that case, murder, first-degree murder, second-degree murder, like in the US. It's not yet there. There is not even a bill about murder, even though the Law Commission report is about 6 or 7 years old now. I can't remember the exact date, sorry. But it's really striking that it is a choice English law has done. It's controversial. French law has never done that choice. It has never been a question. We always had les coups blessures intentionnels sans intention de la donner. Ça date de 1810, ça a toujours été. And I think it's more logical if you think about theoretical and concepts and definition of intention. It's much better to have les coups et blessures intentionnels sans intention de la donner. You can still have the same amount in terms of sentencing, but in terms of theory, it's much better. So that's for intention. Now, intention is only really in the legislation in terms of evidence. So it's not about the theoretical definition of it. It's about how do we prove intention. Okay, so it's the Criminal Justice Act 1967, Section 8, proof of criminal intent. So it's the only piece of legislation with it. And a court or jury, in determining whether a person has committed an offence, shall not be bound in law to infer that he intended or foresaw a result of his actions by reason only of it being a natural and probable consequence of those actions. So natural or probable consequence, it refers to, if you think about the test of oblique intent, it's not simply that the natural consequence or the possible consequence is going to be death. It has to be virtually certain. Okay? That notion that only a miracle will stop the result to happen. The second part of this is shall decide whether he did intend or foresee that result by reference to all the evidence, drawing such inferences from the evidence as appear proper in the circumstances. Now, that doesn't appear very clear. What they mean is that they prove the conduct, they prove the result, and if by proving this they can infer the virtual certainty or the intention, then that's okay. Okay, that's only what it means. And in practice, even in French law, it's mainly what we do. We often infer from the conduct in relation to the result, the intention, okay? And the proof is no easier in French law than it is in English law. I don't think it's ever easy. If it were, I don't think we'll have written so much about it, to be honest. So intention, I did put on the slide murder and manslaughter. So it was 2006, so it's 10 years old now. This Law Commission report that wanted to define intention and define murder, manslaughter, and so on. Since 2006, none of the governments, whether it was the Labour Party, Conservative, the coalition government, ever acted on it. It has never been a project. But it would be, a person should be taken to attend the result if she acts in order to bring it about. And in cases where the judge believes that justice may not be done unless an expanded understanding of attention is given, the jury should be directed as follow, and then they give the direction. So it's actually, this second part is looking at replacing what I put on the slide before, the Criminal Justice Act of 67. Note the term is virtually certain consequence of his or her action. So in effect, the Law Commission is not changing the notion of direct intent and oblique intent, okay? The report will actually change the intention for murder, intention to kill, or intention to cause grievous bodily harm. It's unlikely to be enacted. I mean, it's 10 years old. It might be, I don't know, because the Law Commission this year is doing another report on offences against the person, but without death. So serious injuries, injuries without death. I personally think there is a logic of having the whole lot together. So murder, manslaughter, injuries against the person. So maybe once that is drafted, maybe government will think about acting, but I don't know. It will be good, but it's an unknown so far. Like in French law, it doesn't matter who the victim is, as long as the person, the defendant, intended to kill, okay, or intended to cause serious bodily harm, or whatever is the intention. It could be theft, intention to permanently take away. So it's called the doctrine of transferred malice in France, in England. So that notion that malice, the intention, is transferred to another victim. It doesn't matter, whichever the victim. It will be an offence, and it's been confirmed several times. It's not an issue, it has never been contested. So that's for intention. Now for recklessness. Recklessness is what we would call in France les infractions non intentionnelles. So it's really that part of the offences, les infractions non intentionnelles, et c'est la mise en danger délibérée. Donc c'est pas la mise en danger tout court, c'est la mise en danger délibérée. Donc we are creating a risk and we take deliberately the risk, hoping it will never be achieved, but we're still taking deliberately the risk. English law, so the concept of recklessness in English law was the model for the French criminal law in 1992. Okay, so bear that in mind. Strangely enough, France looked at the English common law in that sense, because it's common law. It's not statute-based. Now, it has been defined differently over the years. It has first been defined subjectively, then we had a couple of years with objective recklessness, and then we went back to subjective recklessness. Now, what is it, subjective recklessness? We appreciate foresight of a risk and a conduct that is taken with that foresight by looking at the defendant's characteristics. So it's not objective, c'est pas le bon père de famille. It's not the reasonable person in English. We don't have the bon père de famille, it's the reasonable person that we're looking at, an ordinary person objectively. It will be completely subjective according to the defendant's perspective. So we'll take into account the age of the person, the sex of the person, if it matters, maybe the learning difficulties, if they have any, maybe their physical disabilities, if they have any. It's quite a subjective test. I put the cases here. It's the same type of case, same type of approach as French law. And the current test is Cunningham test. It's a very famous case that is used to define recklessness. And recklessness is really foresight. It's not really written actually. Foresight of a risk and acting and continuing to act despite that knowledge and foresight of a risk, okay? Because it's not intention, the person doesn't want the risk to happen, to be realized. Okay, so that's absolutely crucial, that's the crucial difference with intention. The risk, the person doesn't want the risk to happen, but they're still acting with that risk in mind, instead of stopping and not going further. Now, negligence exists in English criminal law, but it's not the same concept as in English civil law. So in torts or in contract law, but mainly torts, it's very common, and I would say torts is probably very similar to the French responsabilité délictuelle, which you know is been redrafted by the government avec le projet d'ordonnance, enfin qui n'est plus un projet d'ailleurs, l'ordonnance du 10 février 2016, hein, ça a tout changé les articles de la responsabilité délictuelle qui sont plus 382 à 384, 85 et 86, c'est 1255 et quelques en France. So common negligence in English civil law. The concept is far more narrower. It's far narrower in English criminal law, and it's actually rarely used. It's very close to an objective test, and if you think about recklessness, in a way, it has integrated that notion of foresight of a risk. Okay, of recklessness, but it's completely objective. It's the reasonable man, how the reasonable man would have acted in the scenario. It is gross negligence manslaughter. So we are still in les homicides non intentionnels, hein, donc gross negligence manslaughter. It's not simply a lack of care. You need a duty of care. You need a breach of that duty, and you need a gross breach of the duty, so gross negligence. And it's a high threshold. It's really, does the person, by lack of care, by the breach of the duty of care, deserve actually to be sent to prison? Because the breach is so gross, so serious, that the person should have acted. Okay. So gross negligence, it's not at all the French standard. If you read l'article 121.3, alinéa 2, alinéa 3, alinéa 4, ce sont une définition de la négligence qui est beaucoup plus vaste que la définition anglaise. Et en fait, c'est vraiment la négligence extrêmement grave. So you have several cases. You have Andrews, you have Adomako. It doesn't matter, I would say, for you. But it's a standard much higher than in French law, which translate into, for ordinary negligence, you will not have criminal liability. You will just have civil law liability. Now, for individuals, I don't think that matters too much, to be very honest. For corporation, with corporate liability, I think that matters much more. A corporation in French law is more likely to be found guilty of negligence, especially negligence manslaughter, than it will ever be for England. Actually, to be honest, prosecution of corporation for manslaughter or gross negligence, it's nil, quasi-nil. It's not the case in France. You've got regularly cases with prosecution and corporation being found guilty. One of the factors for a lack of prosecution in England is the definition of gross negligence manslaughter. Okay? And gross negligence injuries, so les coups et blessures non intentionnelles par négligence. So it's one of the main reasons. It's not the only reason. Actually, it's also the notion of corporate liability. But one of the key aspects is the definition of the offence. So mens rea, intention mainly, sometimes recklessness, and sometimes gross negligence. Now we've done actus reus last Monday. We've done now mens rea. You have established an offence. You need to establish a defence. That's the logic of criminal law. That is the same in England. We have established an offence. We need to see if the person can still be liable and have a defence. Now there are two types of defences: general defences and partial defences. General defences apply to any type of offence. Okay, obviously some of them will be more likely for certain offences, but general defences, les causes d'irresponsabilité, when they're general, they apply to any type of offence. So you've got duress, la contrainte, necessity, l'état de nécessité, except necessity is not a, it's not a theoretical concept as in French law, and it's narrower. But you can have necessity when, like in France, there is a storm or an external event happening and the defendant is reacting against that external event. So duress, necessity, one which does not exist in French law, marital coercion. Okay. Now that sounds really strange. It was at common law. It was linked with, you remember the case on Monday when I said the rape, the marital exemption about rape, and it was abolished, okay? And the reason why that there was that marital exemption that, at common law until 1992 is because the wife was merged with her husband and became literally at common law invisible. Well, because of that, they also recognized that the wife could be coerced by her husband into doing criminal actions, because then the wife would not be liable, okay? Because she was not autonomous, so she would not be liable, so her husband could force her to be an offender. So at common law, a wife was presumed to be coerced by her husband into committing crime. Okay, so some women actually used it for their own benefit. They will commit crime without their husband's, obviously, knowledge or approval, but then the husband will probably be found guilty instead of themselves. That's the past. It's been abolished as a defense, as a presumption of a defense, by the Criminal Justice Act 1925, but it's still possible to raise it as a defense. Now, you may think that it's the past, and frankly, in the 21st century, it doesn't really bear any relevance. Well, no. We had a 2012 case with the wife, the person was called Valérie Price, I think. It's either Véronique or Valérie Price. Price is P-R-Y-C-E, P-R-Y-C-E. She is the wife she was the wife of, at the time, a minister in a cabinet. And he had a speeding offense. He went too fast. The fact that he didn't want to declare his speeding offense, because he knew he would lose his driving license, so I had to take the test again. So he said that he was not driving at the time the car, that it was his wife, and his wife knew about it. When they were found out that he actually lied, she said she was coerced because she was his wife and he was the husband. It went to a jury and the jury didn't accept the defense. But she still raised it, and there was no issue on principle to raise it. Okay? So it's not something that is completely forgotten. It's rare, but it's not forgotten. Then you have the possibility of having a mistake of fact. Okay? So it's not a mistake of law, c'est pas l'erreur de droit, c'est l'erreur de fait. L'erreur de droit, vous savez, en droit pénal français, ça a été accepté depuis 92. Avant, ce n'était que l'erreur de fait. Look, that's the same, and it is as difficult as in France to prove. So very rarely used. And then you have self-defense. Self-defense is a misnomer. It confuses everybody, including my first-year students in England, because you'll think that self-defense is about defense of yourself, so protecting yourself. Actually, it's defense of yourself or somebody else, or the property that you own, or the property of another. So in reality, it's the exact equivalent of la légitime défense. Okay? So self-defense is possible. Misnomer because it's not simply about oneself or one's property, it's also about somebody else's physical person or property. It's at common law. It's not statute-based. The only thing that you have from the statute is the concept of proportionality with the concept of reasonable reaction to the threat. So the definition is common law, but and the definition is like in France. You need a threat. It needs to be severe. You need a reaction to the threat, and the reaction needs to be proportionate. To appreciate proportionality, you have the test of necessity and the test of reasonableness. So was it necessary to answer, to respond to the threat? And when it was necessary to answer, was the response reasonable, so proportionate to the aim, to the threat? And that notion of reasonableness is in the legislation, section 76, 2008, Act, Criminal and Justice and Immigration Act. It's very standard, it's very much like French law. To be honest, section 76 is nearly 1 page long. Half of it is, I think, completely useless. Part of it is useful because it says that you don't weight proportionality, reasonableness in abstract. You take into account that the person has to react quickly within the circumstances and as far as they can appreciate the circumstances within the timing that they have. So it's not about an abstract appreciation of reasonableness, it's really according to the circumstances the person is facing. And the fact that they're not going to inquire whether their response is really the perfect response to the threat, they need just to react. So that's the first part of general offenses. Now, you have other type of general offenses. You have consent, which is possible. Consent is only in specific circumstances, so you only have it within a context, and the context is usually sports. So sports like rugby, it could be American football, all the sports are pretty violent. Horseplay, so horse riding, things like surgery, it sounds obvious that a surgeon could not be prosecuted for serious injuries or murder or manslaughter, obviously unless there is gross negligence for manslaughter. But consent, normally informed consent, is a defense. But it's not for certain type of activities like sadomasochism, donc le sadomasochisme. It was a case in England, Brown and others, before the House of Lords, and it went up to the European Court of Human Rights, and the European Court of Human Rights said that England was perfectly entitled to have an offence in that case. And it was serious injuries actually for those people that were involved in the activity. So it is possible to have a defense, but that defense may not always be available depending on the circumstances. There is no equivalent as such to French law. We don't consider it in French law as a defense, we just consider it as negating mens rea. So defense means you have an offense, both in actus reus and mens rea. French law considers it's not a defense, it's about mens rea of the offense. Okay, which personally I think is more logical, but that's a personal opinion. There is no defense like in France by order of the law, par ordre de la loi et commandement de l'autorité légitime. Simply does not exist. I think it's because culturally and historically, England never had that possibility. Never had a situation where the government forced people to commit illegal actions. Mind you, when you think about French law, it's hardly even ever applied. Even during the Second World War, it was not even accepted after the Second World War to justify certain actions with people who were literally kidnapped and forced by the Nazis to commit certain offences, including rape and murder. So I'm not sure it's really relevant. I mean, I don't think it's something that England misses much about. Now, the other one that is a bit strange when I explain it, it's insanity, intoxication, and automatism. Okay? Now, insanity, automatism, and intoxication are about the same problem, which in French will be le trouble psychique ou neuropsychique. It's the same, you have 3 defenses in England for one offense in France. Now, the trouble psychique and neuropsychique in French law is vast. It can include intoxication if the person has reached the stage of being in delirious tremens, le delirium tremens. Vous savez, c'est quand une personne est alcoolique depuis très longtemps et l'alcool a en fait détruit une partie de son cerveau et la personne littéralement a des hallucinations quand elle recommence à boire. That is taken into account in trouble psychique, neuropsychique. The difference with insanity and automatism, what is it? Well, they're both le trouble psychique and neuropsychique, but they are linked with procedure. More or less, before 1995, if you committed murder and you pleaded insanity, so le trouble psychique, you would not go to prison, but you could go to the mental hospital for the rest of your life. The judge has that possibility. So some people simply ever refuse to plead insanity, okay? Or they tried to plead either intoxication or automatism. And automatism emerged from insanity because if you pleaded automatism, the judge would just have to find you, and it was, the jury found that there was automatism, the judge will have to release you. You couldn't go to prison and you didn't need to go to a mental health hospital. Okay. So automatism emerged as a way to escape the defense of insanity. Now they have to find criteria to make the difference between the two. And that's where it becomes a bit absurd. England is a bit concerned and knowledgeable that it is absurd. But the rule is that automatism is external factor, insanity is internal factor. So automatism is brought by a person losing control of herself, but because somebody else started to created a situation in which she or he loses control. I can't remember if I went further in. Yeah, so I go back on it, so I won't continue because it's the break. So we'll go back on it for insanity automatism, so don't panic. The main thing to remember is that those are general defenses, all of them. So all offenses. Now you have, and we'll do it after the break, partial defenses. Partial defenses only apply for murder, and you need to prove murder. So you need to prove actus reus and mens rea of murder. Okay? And then you can have two ways of escaping murder. So we'll see that after the break. Take 10 minutes, and that's it. Okay? Thank you.